All right, Autumn, thank you. Welcome. It's time for our Midday Minutes. So, Florina Achtyl, you are our legal analyst, and I wanted to bring you in because all last week, even into this week, we've been covering that Deputy Kenneth Achtyl trial, the trial out in Orchard Park over that arrest from the 2017 tailgate. But I really want to do like a deeper dive on some of the issues that came up in that trial. Right now, today, we've been telling you about the back and forth between the DA, the PBA on what happened there. But something that was interesting is that we never did hear from Deputy Achtyl during that trial. Why is it something the defense might not have done, putting him on the stand?
So a defendant always has an absolute right not to testify against himself, and whatever he says can very easily be used against him. It's a balancing test to determine whether or not it would be a good idea for somebody to testify in their own defense. Certainly, were he to testify on his own behalf, he would be subject to a cross-examination by the prosecution, and a lot of evidence could come out that would hurt him through that cross-examination.
So you think they decided not to put him on the trial because it could have done more to hurt than help the trial?
It oftentimes very well may do more to hurt him than to help him. Sometimes when the witness is a very sympathetic witness, you do want to put him on so that the jury can hear from him and perhaps sympathize with him. But he'd be subject to that cross-examination. And
I do want to cue up some of the video. We've seen this video before, but this is video of the arrest on that day. This is video that the defense actually released to us. And while we're looking at this, I want to break down some of those charges. So he was found guilty of misconduct, of reckless assault, and of falsifying records. But what he wasn't found guilty of is intentional assault. So in legal terms, that intentional assault, does that mean he went into the, can you explain to me why he might not have been found guilty there?
It's not always easy to establish what a person was thinking, and in order to be able to prove that someone acted intentionally, since we can't read people's minds, we would have to rely on the circumstantial evidence that supports whatever we believe their intent was. In this case, the jury did not believe that his intent was to injure this person or cause physical injury, but they did believe that because of the way he acted, that conduct was reckless.
Okay, so that was him maybe getting out of the car in the first place to go after this young man.
And using his baton in the manner in which he did to cause the facial fractures.
Right. And the sheriff hasn't said whether he's going to be fired or not. Right now he's out on paid leave. But something we were talking about just before we went on air is that this wasn't an excessive force trial because this was a criminal trial and excessive force is a civil term, you said.
Right, so an excessive force case is a civil case for money damages that will certainly come later by the young man who was injured. And he's going to sue, I assume, both the sheriff and the department for causing these injuries as a result of using force that he will offer is more than the force necessary for a lawful arrest, and he will certainly argue that the arrest in and of itself was not even lawful to begin with.
So when it says Belcito seeking general special and punitive damages, that's going to come during the civil portion?
That's in the separate, later to follow civil lawsuit.
Okay, great. And for now, I want to pull up some sound here we have from the DA because he's talking about some of Belcito's actions. I want to see if we have some of that.
The fact that this kid swore, and the fact that this kid, quite frankly, I'll concede, may have been acting like a jerk, during this whole process, all right? That factored into the totality of the circumstances here. I agree, all right? And I'll concede that the kid, didn't act perfectly, all right? But at the end of the day, he didn't deserve to get a broken nose and a concussion.
And the DA also said after that, he said cursing at an officer is not a crime, but he, quote, didn't deserve that. That's the bottom line. Belcito, originally, he was charged with disorderly conduct, obstructing governmental administration, but all charges were dropped.
So I don't think it's a question here of whether or not he deserved that kind of treatment. That's a very different analysis. That's not a legal analysis. The legal analysis here is, in order to pursue charges against this young man, you would need to have that officer testifying against him. That officer was convicted of falsifying a record. Right. He's not going to be a credible witness. So you can no longer use that officer to testify against this kid. And if you don't have the officer, you really don't have any charges against this kid. Okay. And in terms of whether or not this officer will be fired, I really don't see how he can continue working as an officer, potentially testifying in other criminal cases against other people, where he's been convicted of falsifying a record.
Right.
So that's going to be used against him in any future trials where he testifies as a witness, because frankly, his credibility is shot.
It's shot. Okay, Florina, that's all we have time for. I have plenty more questions, and I'll try to do some of that, break it down, and put that online for you all to see. For now, we're going to send you to break. We'll be back with more weather and news just after this.